Good afternoon. My name is Bruce Smith. I'm an attorney at the Goosmann law firm in Sioux City, Iowa. And for those attending, this is our first live webinar. Many more to come, discussing information and legal topics of interest to those who choose to register and participate. Before we get started, I would encourage you to use the chat box if you have any questions along the way during the presentation. We'll try our best to respond. There will be a short question and answer session at the end of this webinar presentation. Now, keep in mind, there is a disclaimer that you should read and appreciate that we are not representing you as a law firm on this particular subject. We are giving you advice, and if you think you have problems involving this subject or any other matter, you should consult your attorney. So we trust that everyone listening in is aware of that fact. The subject that I will be discussing today deals with maybe an unknown, relatively unknown topic concerning our federal government and the degree to which several agencies involved, participate in joint enforcement in order to enhance and increase the possible penalties that employers and individuals may be subject to when we're discussing the areas of health and safety that people know about in terms of, say, OSHA, in conjunction with environmental compliance, which is a whole different area of federal and state law, but actually has quite a bit of bite and teeth to it. But before I get into the subject itself, I wanted to give you a little bit of historical background. For those of you who are old enough to remember, such as myself, when President Nixon was in office, he was famous for accomplishing several things, some of which were good and some of which were not so good in terms of Watergate. But one of the things he spearheaded was the creation in the early 1970s of the Occupational Safety and Health Administration, as we commonly know it to be OSHA. And that deals with workplace safety, where employers have an obligation to follow rules and regulations, as well as anything else they would like to implement to make this workplace a safer place to be. And it, throughout the decades since the early 1970s, has been very controversial in terms of whether it is or is not effective. Are the penalties and fine provisions under the existing law adequate? Have they kept up with the times? And have there been movements within the political realm to increase those fines and penalties? It's been rather politically contentious in Congress, as you can imagine. The OSHA initiative through, and I'm not going to state a political preference, but the Democrat Party in Congress historically has sought to increase fines and penalties to be imposed upon employers for violations of occupational safety and health regulations. And as a result, politics, being as it is, tends to make such initiatives slow in coming. So OSHA has basically been living under age-old fine and penalty provisions that have, in some people's minds, become inadequate. You then have the Nixon initiative back in the 1970s of creating the Environmental Protection Agency, completely different agency of government that regulates the environment in terms of clean air, clean water, hazardous waste, and other areas. But the EPA was granted, and it's been amended to increase its fine and penalty provisions civilly against employers in a much broader aspect than what OSHA ever has had, and by comparison has very little authority compared to what the EPA can do to an employer. You'll note on the screen that I have highlighted the fact that OSHA's top penalty per violation in the workplace is a $70,000 fine for a willful violation. That would be the maximum amount that an employer can be fined. And rarely do you even have a $70,000 maximum penalty imposed, even with a willful violation written up. So you can imagine there might be multiple violations occurring by an employer, which can, make the penalty fairly substantial. But when you compare that to the EPA, that has a per violation maximum penalty of $250,000 per day, and if you have multiple days involved in terms of illegal discharging either into the air or to the water, or a continuing violation involving hazardous waste, those numbers can really mount up into the millions and millions of dollars. So, as it has stood by federal regulation, it's really the EPA as opposed to OSHA who has had the ability to significantly fine employers and, as we'll discuss, individuals for violations of the law. You also, within the component of civil fines and penalties, you do have criminal sanctions that can apply against companies and in certain situations against individuals if there are violations of the law. Now, the federal government provides varying aspects of rules and regulations in terms of criminal penalties. But to give you an example in that regard for the fine potential involving criminal sanctions, the EPA, if you are convicted of a crime, which we'll talk about, on an individual basis, can have a person in prison for up to 15 years for any situation that involves the death of someone or egregious bodily injury resulting from an EPA violation. You might have a hazardous chemical exposure, a leak of some kind that ends up killing an employee or a contract employee. You may also have very egregious personal injuries that could result from those type of releases. On the OSHA side, by comparison, you find that it's very weak in terms of criminal sanctions and penalties. Basically, what the OSHA law currently says is if there is a worker safety violation caused by the employer that results in the willful violation of a regulation of the death of that worker, the most that can be prosecuted criminally is a misdemeanor homicide, and that can be imprisonment up to 6 months. There were some sentencing guidelines that for individuals meant you could be in prison for up to 6 months and now fined up to $250,000 personally if you were involved in the commission of that willful violation, resulting in the death of another employee. And for corporations, under OSHA law, you also can be prosecuted criminally, convicted of a misdemeanor, and fined up to $500,000 for that particular incident. But you can see that the balancing effect does not exist between EPA, 15 years imprisonment, millions of dollars in fines, versus OSHA's misdemeanor conviction for up to 6 months and a $250,000 fine for the individual. That particular discrepancy became a concern to the EPA and to OSHA. And it was pretty much ineffective in terms of what OSHA historically has been able to do from a criminal penalty standpoint versus the EPA. So the disparity between these agencies created a need to see what could be done to have a more joint enforcement impact, combining OSHA and EPA in situations where you may have violations that cross over the line into both areas. In 2006, there was a Worker Endangerment Initiative by agreement entered into between the three principal agencies of our federal government involved in these areas, and that is OSHA, EPA, and Department of Justice. Hence my topic being entitled Triple Jeopardy. However, the triple refers to the three different agencies of government that combine forces, so to speak, in order to accomplish enhanced, larger-based fines and penalties against companies and individuals who violate OSHA and EPA law, or vice versa. And a little bit later on, I will discuss some examples of that. But I quoted from the Department of Justice website on Worker Endangerment Initiative discussions. And I won't read it verbatim, but it gives you the feeling that I just discussed, that EPA and OSHA have decided they want to enhance the penalty structure for violations of OSHA law. EPA already has that hammer and sickle, but OSHA doesn't. So along comes OSHA, the big brother, and they're going to help out, or EPA, the big brother, they're going to help out OSHA now. So that if somebody happens to violate both an OSHA standard and an EPA standard, not only will EPA wallop you, but you'll get another hammer over the head by OSHA. And of course, Department of Justice, most people appreciate the fact they have a criminal prosecution system at the federal level. So the initiative basically suggests the Department of Justice will now hop on the bandwagon and be the third party to come after you in terms of criminal enforcement. So now all of a sudden in the United States, and it predated a little bit before 2006, but became the official initiative in 2006 to do the triple whammy, OSHA, EPA, and DOJ. Now, not every OSHA violation is going to constitute an EPA violation, but the initiative that I just mentioned, the Worker Endangerment Initiative, beginning later in the 2006, 7, or 8 era, involved the retraining of OSHA inspectors to now begin looking not only for safety violations in the workplace, but environmental violations. Now, what is of particular relevance on that point involves the chemical industry and manufacturing industry in the United States. People are aware of the fact that we do have lots of hazardous chemicals in lots of manufacturing facilities, in addition to the chemical industry business. I think we're all basically familiar with petroleum chemical refineries down south. You know, we had the BP oil spill in the Gulf of Mexico in 2010. But the mere fact that even manufacturing facilities, including food processing facilities, have hazardous chemicals as part of their storage and processing aspects of their business. So if there ever is an OSHA inspection that may not have even at first glance prompted them to be there because of a hazardous chemical spill of any kind, they may be asking about environmental compliance and getting into the issues of what's over in that storage tank, and they're going to want to see documentation, etc. And based on employee interviews that they conduct, they may ask questions well beyond the worker safety issues they're asking about, but ask employees if they have been trained on environmental compliance. So all of a sudden, you've got both EPA and OSHA in a facility, even though it's just the OSHA inspector at the moment, who's fishing around for EPA compliance or non-compliance as issues. Now, under the federal law, you have a very common overlap where much of the joint enforcement initiatives have come to play in terms of EPA and OSHA, and that deals with hazardous chemicals. Under the EPA laws, they have a risk management plan regulatory process, and OSHA has a very similar and actually an overlapping type of regulatory scheme that mirror images the risk management plan, EPA side, and OSHA calls that process safety management. Now, both programs are designed to make sure that the facilities and the employers have in place a program that manages and polices and reports any type of chemical activity that involves the best practices concerning the chemicals involved. So that what ends up being the case is that if you're an OSHA inspector and you go out to investigate, say, an employee complaint involving the hazardous release of a regulated chemical, they're also there on behalf of the EPA. So now you have two different agencies of government investigating the same regulations, but as a facility, you will be subject to fines and penalties separately by each agency for the same violation. We have historically in the United States believed that we have protection against double prosecution, the double jeopardy clause that prohibits you being tried twice for the same offense. Well, the Supreme Court many years ago held that agencies of government, even if their regulations overlap, can civilly and criminally prosecute you for the same violation. So much for the double jeopardy clause under the Constitution. So when you throw in the Department of Justice as what I call the triad of coordinated agency enforcement between OSHA, EPA, and DOJ, you have had the Worker Endangerment Initiative now being enforced in particular situations where you have the overlap of jurisdiction, say in the areas I've talked about. I have personally been involved in that aspect of triple jeopardy involving past clients, and the very first case that dealt with this overlap on risk management and process safety management and hazardous chemicals goes back to the year 2008. And I noted in my PowerPoint what was interesting about the HERSHEY company in Pennsylvania, and their situation was that they had been inspected by OSHA to see if they were complying with the process safety management hazardous chemical regulations in their facility, which included anhydrous ammonia, and they were found to be deficient. They were then cited by OSHA and told you need to pick up your program and do it right. And OSHA came back later, a year and a half, 2 years later, and found out they hadn't. Now, there had been no incidents, no worker deaths, no injuries, just lack of program compliance. So OSHA had a bug up their butt and they went to EPA because the OSHA violations happened to also be a risk management plan hazardous chemical violation for EPA. So then EPA began to investigate the company. And again, no accidents or injuries. And EPA then referred the matter over to the Department of Justice to investigate as criminal noncompliance because this appeared to be a willful violation of the law after the company had been warned originally by OSHA to get their act together. So being unresponsive to compliance, they were dragging their feet with EPA information requests. They ended up as a company having to plead guilty in a plea agreement to a criminal offense of violating the Clean Air Act involving hazardous chemical management and reporting, and also paid a fine of $100,000. And in addition to that, had to spend whatever money necessary in order to get them into compliance, certifiably so, with the risk management and process safety management programs. So following the enactment or entering into the agreement for worker endangerment as an initiative, a non-incident matter occurred without worker injury or death, resulting in the coordinated enforcement for enhanced penalties. Another case that I have highlighted involves Tyson Foods, and you will begin to notice that the Worker Endangerment Initiative is one that tends to apply to the more egregious situations. The Tyson Foods incident involved a repeat situation. An employee down in Arkansas was killed when he was overcome by hydrogen sulfide fumes in a chicken rendering plant. And the company on the first violation was investigated by OSHA, and they were fined. There was no criminal prosecution involving the first violation, but there happened to be a second violation at the same facility involving the same rendering process involving hydrogen sulfide. Now, if you're familiar with hydrogen sulfide, it is a very rotten egg odor type of ambient air constituent that you smell, but in highly concentrated levels, it is lethal. So now you have the beginning of an egregious situation developing, even if having an employee die isn't egregious enough. They repeat the exact same incident 2 years later. Well, guess what? The EPA is reported to by OSHA, and this happens to also be a Clean Air Act violation. So the Environmental Crime Section of the Department of Justice gets involved, and they seek enhanced punishment and penalties against Tyson because they weren't adept enough to figure it out the first time. And those are considered aggravating circumstances that justify the triple jeopardy involvement of OSHA, EPA, and Department of Justice. So in the end, Tyson, they pled guilty to a criminal violation against the company and were ordered to pay $500,000 fine and institute remedial efforts to make sure that this would not happen a third time. So I do not apologize for Tyson Foods. They obviously didn't have a system in place to react properly the first time, and let that be a lesson to all who are in the business of doing business, that if you have a problem arise, don't repeat that problem, fix the problem so it never happens again. You then have another situation that was widely reported in the press going back to 2007 involving Beef Products, Inc., where an announcement was made that originated from an ammonia release occurring in a Waterloo, Iowa facility of beef products, involving over 1,000 pounds of anhydrous ammonia being released into the plant through a line break that EPA said should never have occurred during construction. One employee was trapped and died. 2 others were seriously, permanently injured, and a dozen more were taken to the hospital as a result of this release. So this was an investigation that started with OSHA because of workers dying and being injured. And ultimately, the Iowa OSHA department in Des Moines of record fined the company over $600,000 for any number of violations that occurred as a result of that release of anhydrous ammonia. But this case probably illustrates the quintessential aspect of Worker Endangerment Initiative, and that is that the Iowa OSHA people went to Kansas City, Missouri, and reported the incident and gave them all of their fact-based investigation files, which then meant that the EPA saw this as a worker dying, several others being hurt, as a case that needed their involvement. And you have on the EPA side, you have civil investigations where they will fine facilities dollar penalties and then require facilities to spend money to come into compliance. But in that case, it also involved criminal investigation. And the Northern District of Iowa U.S. Attorney's Office was involved. And you had 3 different levels of enforcement by way of agencies. Again, OSHA, EPA, and Department of Justice. And lest we be too conservative in suggesting to people that there tends to be an attitude among workers for companies that it's a company problem, it's not mine. Well, when you get into specific cases, you'll learn that that isn't the situation. Individual people can be in trouble criminally as well as civilly for not complying with OSHA regulations and with EPA regulations, which can sometimes mean being subject to criminal investigation, because there are certain situations where management level employees, although trained to the contrary, will make decisions that aren't in compliance with the law, or not in compliance with what the program is in place to be followed at the facility. And that is the last thing that people want to face in their life, is having to be investigated in what they thought was just an OSHA case right into a criminal investigation with the federal government. That's the worst of all worlds, and something that from a personal standpoint, it's in an employee's interest as well as the company's to comply with the law. Otherwise, both the employee and the company may be criminally prosecuted. I quoted from the beef products case the comment about that particular investigation where somebody by the name of Carl Brooks, a bureaucrat, said the 2007 incident in Waterloo demonstrates that having a plan only on paper increases the risk of accidental exposure to both employees and first responders. If you wish to read between the lines as to why that means a more egregious situation warranting triple jeopardy, in this case against beef products, what he's saying is that as an employer and a management person, your job is not done by simply creating written policies and plans to be followed by everyone. You actually have to walk the walk. You talk the talk isn't good enough. And when people are seriously injured or die, you're going to see triple jeopardy as a very real possibility nowadays. especially during the current administration in Washington, which tends to be much more pro-employee than pro-business. So that type of political philosophy filters down through the U.S. attorneys who are appointed by the current administration and who make those decisions on whether to be involved in triple jeopardy or not. So it's worth noting that even if you have policies and procedures in place, that's not going to immunize you from the triple jeopardy threat that can come to bear. Now, hold on just a second. My screen is frozen for a moment. Hold on. Bear with us. Okay, that would be the next one, the implementation. Here we go. What's symptomatic of the Worker Endangerment Initiative and the products case is simply the fact that it truly started out as an OSHA inspection, led into the EPA regional side, and led into the Department of Justice, all looking at ways to penalize and fine the company. Perhaps the case that started discussions about let's have this initiative in collaboration between EPA, OSHA, and DOJ was British Petroleum, not with the oil spill in the Gulf, but back in 2005. There's a petroleum refinery down in Texas City. It was a massive, huge explosion, killed 15 people, injured over 170 more people, and it brought in every conceivable investigatory agency you can imagine. But the principal ones starting out was OSHA, followed by EPA, followed by the Department of Justice. And it was a case that, much similar to the Bhopal, India case, where they had a chemical release that killed thousands of people over in India, that actually precipitated the process safety management and risk management laws that we currently have in place in the U.S. But I listed some of the findings in that BP 2005 incident, which actually involved the release of ignitable vapors that were in close proximity to trailers occupied by people, both from a business office standpoint as well as living quarters, that had British Petroleum complied with the risk management plan type of regulations, they would have moved those type of facilities farther away from the hazardous area, acute hazardous area, but they didn't. They didn't comply with the program. So the organizational failings in that particular case involved a number of, I say, temptations that sometimes companies allow themselves to fall into: corporate cost cutting, a failure to invest in plant infrastructure, a lack of corporate oversight, both in terms of safety and EPA, a defective management of change process. That's where you have to go through a lengthy process of planning out and managing any changes in systems that you're going to make involving hazardous chemicals, inadequate training of operators, a lack of competent supervision for startup operations, poor communications, et cetera, et cetera, et cetera. Now, to one degree or another, that sounds awfully familiar to me and my legal experience interfacing with companies, that to one degree or another, they tend to fall short in those areas. And if you fall short, we know what the worst case scenario can be. So then the question is, why would a company ever want to fall short? And if it costs too much to comply, then I guess you really shouldn't be in business. But normally there are ways to comply that can be affordable, and you can kill two birds with one stone. Even today, there are still lawsuits lingering from that 2005 disaster with British Petroleum involving family lawsuits. I did give you some of the numbers that resulted from that particular set of violations, where OSHA fined originally $21 million, then a follow-up fine of $87 million in this BP. EPA, in addition to criminal sanctions, imposed a $50 million penalty for civil violations of the Clean Air Act. At that time, was the largest set of fines civilly imposed against an industry operating in the U.S. for Clean Air Act violations. The reminder is that between 16 and 18 people a day die in the United States due to workplace accidents and injuries. You have 130 people dying every day from the lingering effects of exposures in the workplace to diseases and illness. And you have the additional concern that once the federal government begins using the Worker Endangerment Initiative for real, the more likely they will expand the application of that concept yet to egregious situations, but will not require people having to die. And they will use create examples to use to incentivize other employers to get with the programs. So we are ironically taught fundamentally under our system of government that you cannot be subject to double jeopardy or being tried for the same offense twice. But the concept in reality is that you have federal agencies of government duplicating the regulatory process, in this case, a hazardous chemical regulations, for which you can be separately fined and penalized as a company and punished individually in certain criminal cases for violating the law. Whether you consider that fair play or not, it is a reality which should give employers an even greater incentive to make sure that they're walking the walk when it comes to compliance with such federal laws and regulations. You have a similar initiative by OSHA in order to beef up its penalties when you don't have an EPA overlapping violation, where you have co-employee exposure due to a program not being implemented as it should be that affects all employees. It used to be that if OSHA came in and investigated a violation, they looked at the specific incident and then proposed fines and penalties accordingly. Say an employee didn't lock out or tag out a piece of equipment. Now, if OSHA comes in and finds out that your program and training was deficient, say on lockout, tag out, they're going to say, well, it wasn't just the one employee who hurt himself who was adversely affected. We think all the employees in that facility constitute a separate violation. So if you employ 300 people, you're not going to multiply the number of violations times 300 times, whatever the dollar penalty is. All of a sudden now you have penalties in hundreds of thousands of dollars, not just a $500 or $2,500 proposed penalty. So the Worker Endangerment Initiative kind of illustrates the way your federal agencies are attempting to work around their limitations in order to enhance the penalties and fines they can impose. And I would also tell you a little bit off to the side of this issue is the personal liability is not only criminal, potentially, depending on the nature of the violation, but you also, for instance, in the state of Iowa, you have co-employee liability. And what that means is that if I'm an employee and I am hurt by the gross negligence of another fellow employee, I can sue that other employee or employees in civil court in front of a judge and a jury to be paid monetary damages in a civil case for their gross negligence. And that means that it isn't just the other employee who may have made that bad judgment call, but maybe his manager. I could go all the way to the top in theory. So employees need to understand that they're not protected behind the name of the company if they do something wrong. They may be sued civilly, just like EPA and OSHA can come after an individual employee for criminal violations. So it's both company and individual awareness that must exist in order to avoid these type of dire consequences through Worker Endangerment Initiative or otherwise. So this particular webinar, its purpose has been to make you aware of the extreme downside that can occur with coordinated enforcement efforts between federal agencies that create this triple jeopardy effect. And I think that the strong arm enforcement of the Department of Justice, which has both civil and criminal enforcement powers, is icing on the cake now. And it is a real threat to companies and individuals that no one can afford to ignore and will need to evaluate the degree to which they are in good faith achieving compliance with the law. Are there any questions from anyone about the Worker Endangerment Initiative? I have one here. The question is, have there been any other attempts by OSHA to increase the fine potential without new congressional laws or joint initiatives between federal agencies and government? That would be the co-employee exposure situation I just mentioned. And there's a mixed bag of opinion based on court review of those types of situations, depending upon what federal jurisdiction you're in, as to whether that is or is not an allowable enhanced penalty initiative for OSHA to pursue, but it's out there. One other question is, what can a company do to minimize risks of events that might trigger joint initiative enforcement of criminal prosecution in cases of accidents and injuries? Well, it's a broad-based question. However, the answer lies in acting in good faith to implement and train your employees on what the regulations require, and then making sure that you have an effective oversight and auditing program in place to ensure compliance going forward and to correct any deficiencies that you may find regarding compliance. The government looks heavily at review, follow-up, auditing, and enforcement of the compliance programs to evaluate the egregiousness of the violation. And I would suggest to you that there are times when if you train an employee and it's verifiably signed off to by the employee to do something a certain way, and if they choose on their own to violate their own training and the employer has done nothing to encourage that violation, that the employer can be held not liable for a violation of OSHA law. And there are instances when employees are pig-headed, or they're just stubborn, or they decide to cheat and not lock out a piece of equipment or follow the rules, and no one from management or otherwise encourages them to do that. That can be a defense under the federal law for an employer to assert if he's ever cited for a violation. So that would be the best advice I could give to anyone to follow in terms of staying out of trouble. There will always be some kind of trouble, but minimize the egregiousness of it and act in good faith. Any other questions? Okay, if that's it. I do appreciate everyone's participation, and we look forward to further webinar presentations by the Goosmann Law Firm. Have a wonderful day.